Welcome everybody to today's micro lecture on law and time. You might wonder in which way law is related to time. As you can see, today's micro lecture is structured in the following way, or respectively we will cover the following questions. The relationship of law and other disciplines. We will need to look at this question first. Then we will look at a situation where law lags behind, where very often we have references to ethics and values. We will also look at questions of scientific uncertainty, where a certain decision has to be taken. So that refers to the precautionary principle. We will also look at some questions how law changes because public opinion in one field has changed, and we'll see how that affects law. And last but not least, we will also look at the normal procedure, how law can be changed, so irrespective of, let's say, external criteria. So here we have some guiding questions which can already make you reflect on those questions by now, and by the end of this micro lecture those questions will be answered. So first question, which questions can arise if one discipline, law, refers to other disciplines? So what questions can arise at the interface of those two different disciplines? Since it often takes some time for legislation to be adopted, which approach should be taken in case of rapidly evolving technologies? We've had those questions concerning biotechnology years ago. Nowadays we have very similar questions actually in the field of digitalization. What decisions should be taken in case of scientific uncertainty? So we don't know as much as we would like to know. And the last question, how does law change, so the ordinary process, so to say. As you can see on this slide, law, of course, can refer to legal concepts or to legal principles, but often there would be the necessity that law refers to other disciplines. And that can be ethics or values as a branch of practical philosophy. But law can also refer to natural science. So we have that situation very often if in healthcare that law has to refer to medical analysis and then reintegrate this knowledge back into law because it would have certain consequences. So just to give you one example, if in the field of EU cross-border healthcare, we want to answer if there is an undue delay, so if a patient had to wait too long to get a treatment, this question has to be answered by a medical doctor. But then, of course, this information, if we feed it back into law, would have some legal consequences. So basically, as you can see, law referring here to science and then reintegrating that knowledge. We could have what we can call an absolute approach, which means that we take the information and reintegrate it into law and we would not change it, or what in literature is called a relative approach, so that whatever information we get, for instance, from science, we would not integrate it in an absolute way, but in a way that this information can be seen to be in line with the legal system as such. So we find that approach when it comes to notions of ethics and morality, when it comes to law and science, so in various fields, so to say. Now, as you know, very often law lags behind new technologies. So the law is not adapted as quickly as new developments show up. Where can we observe this phenomenon? As you can see, for instance, when it comes to drones, very often there were not the legal provisions to deal with new possibilities, but also new challenges. The same very famous discussion of self-driving cars. Do we have the laws? How should the laws be tailored for this new situation? If you think of accidents caused by self-driving cars, the same for robots and also for artificial intelligence. where also very often we don't have the laws to make a framework for those new developments. So if we have this gap between law and science, very often nowadays we have law referring to ethics or to values in order to provide for a good solution for those new challenges. Very often also we have a situation, as you can see on this slide, where today we have to take a decision, but we don't know for sure if a certain danger really exists or how serious it exists. Let me give you one example. So, for instance, when there was the BSE crisis, so as it was called the mad cow disease, there was some data indicating that certain meat would be infected and it could have certain negative consequences for the health of people consuming that meat, but not all the information was available. And as you know, importing meat from another country, as it was from the UK to France, for instance, that's free movement of goods. So also the EU had to deal with this situation, and the question was, can the EU, for instance, take protective measures before waiting until there is a scientific certainty? So that is defined here, as you can see, the possibility to take protective measures without having to wait until either the reality or the seriousness of certain risks due to the BSE become fully apparent, or until the adverse health effects materialize. So that's what we call the precautionary principle. You can see on the slide in which fields that can be applied: environmental law, food law, the law on communicable diseases, but also in the fundamental freedoms. And as you can see, there are different actors who, according to EU law, have the possibility to take those measures before we know everything about the risks. So that's the precautionary principle, and you can find further information on this slide. Another very interesting topic, if you look at the relationship of law and time, is the development of law due to external factors. So as you can see from this slide, there are some I gave you some examples where public opinion has changed, and we can say is still changing nowadays. So same-sex relationships, marriage or partnerships, that's a topic where we have a movement in public opinion, even worldwide. The same topic of abortion, for instance, which was strictly illegal in Ireland. Public opinion has changed, also the law has changed, or also the consumption of cannabis would be another very famous example where we can see a shift from being more restrictive to being more liberal, even worldwide. So we have external factors in the past and nowadays, and they have changed. Let me give you two examples. If you look at those pictures, one example maybe is a little bit less serious, the other one a little bit more. So if you know this movie of Ted 2, this living teddy bear, if you look at this screenshot, which wanted to marry his girlfriend, but the legal challenge was, as he was not considered to be a human being, he was not able to marry his girlfriend. So in this court proceeding, his lawyer argued that in the past there hasn't been a teddy bear who is moving around like a human being. So therefore, in the past, the law was okay, but now we have this living teddy bear, and so the law now should change. If we move on to the more serious example, this picture taken from the Jefferson Memorial in Washington, D.C., you can see the requirement that law should go hand in hand with progress. So, or as it's mentioned, to keep pace with the times. And as you can see on the bottom of this quotation, we would also not require a grown-up man to wear the trousers that he was wearing when he was a child. And so also here law has to keep up pace with time. There was a very interesting overview in The Economist some time ago, and if you look at that, it's very important to emphasize that the law itself has not changed. So the US Constitution, you might know, is rather difficult to be changed. So the Constitution has not changed. What has changed is actually the attitude of Americans. And you can see the different examples that are stated here. So segregated schools, interracial marriages, abortion, and the most current one, Oberquell, same-sex marriage. So the law has not changed, but public opinion has changed, as I've mentioned it before. And so the US Supreme Court, the judges, were, as it's indicated here in this article, they were willing to change their case law. Again, the US Constitution has not changed, but they were willing to change their case law because public opinion has changed. And as it's mentioned in this quotation, if at least half of Americans were on board, then they were willing to change their case law. So after those examples, let's get back. Now, what's the normal procedure to change law? As you can see from this separation of powers, normally it's not the judges, also not the executive, but the legislative power, so the parliament at national or at EU level, that has the power to change law. But of course, that process can take some time. There can be legal challenges, there can be political challenges, so that there is no compromise. And that should be the normal procedure to change law. If that procedure lags behind new technologies, then, as we have seen earlier, that can lead to the necessity to refer to non-legal concepts. So, if primary law has to be changed because technologies or another situation has changed, all EU member states have to react. If secondary law has to be changed, the European Parliament and the Council of Ministers would have to change those EU documents, EU directives and EU regulations, and the same at national level. So a national parliament has to change national law if there is the necessity to adapt those provisions. So that's the literature mentioned on the slides, and now you know. The challenges that can arise if one discipline refers to another discipline. That's precisely the question if this knowledge should be integrated in an absolute way, so unchanged, or if that knowledge has to be reflected in the legal order. So that's what we call the relative approach, which is given preference here. As I just mentioned, the reason why law lags behind can be precisely because maybe there is no political compromise amongst the political parties in a parliament, and that might be a political reason. It could also be a legal reason because a legislative proceeding simply can take some time. Very often, if we have such a situation where law lags behind, we have references rather to non-legal concepts like ethics, also to values, to fill the gap, so to say, to provide for an adequate solution. We've also seen that if we don't have the scientific certainty at a moment where a decision has been taken, and maybe where a decision has to be taken very urgently, as it was the case in the BSE crisis and also for other examples, then EU law provides for the possibility to take precautionary measures. So even if we don't know if a risk would occur or in which serious way it would occur. And as we have just seen, law can also be changed in the normal way. So the legislative procedure at the different levels. But as we have also seen from those US examples, it can also be public opinion that changes, which also might lead to different case law. So hopefully now you know about the relationship of EU law and time, and see you next time.